N. et al. Versus Manuel M. Sanchez.
There it is. Where is it? There it is. Good afternoon.
I'd like to reserve 2 minutes for rebuttal
2
at
minutes.
the end, please.
Very good. And are you Miss Hollis?
Yes,
And you're representing yourself?
correct.
Very good. I'm pleased that you've had the opportunity to see 2 prior cases, so you have an understanding that we want to hear what you have to say, but at the same time, we may or may not ask questions of you. And so you have a total of 15 minutes to present your argument. You may reserve up to 5 of that if you wish to respond to what the other attorney, opposing counsel, has to say. Do you wish to reserve any time?
I wish to reserve 2 minutes, please.
2 minutes?
2 minutes.
Very good. We'll set the clock for 13, and the floor is yours.
I am looking for a reversal of a lower court decision. The defendant had put in a motion for dismissal pursuant to Rule 12.025 that the defendant was not properly served. On October 6th, an email from my previous attorney was sent requesting an address to serve the defendant. He lived in a trailer park, and the deputy tried to serve him, but there were multiple trailers, so they had no clue where he lived. On October 8th, a reply was from Lauren Redford saying that they were waiving service at that time and would get the complete address from the defendant and provide it to the previous attorney. This was never done. We continued to settle parts of the case, as there were 3 parts to this case. There was injury to the minor child, there was property damage, and then there was other physical damage to myself. And that is still ongoing treatment. They settled the minor child injury on 5/3 of 22, and within less than 30 days filed for the dismissal. At this point, we had been settling parts of this case in good faith because there was no, the extension of time was never revoked by the defense. Under Rule 6.02, there's excusable neglect, and there's 4 criteria for that. The first is the danger of prejudice to the party opposing. In this case, there would have been no prejudice because if he had been served, the case would have proceeded as it had been at that point, settling the parts of it as we had settled it. 2, the length of delay and the potential impact on the proceedings. If we had actually served him and settled the case sooner, that would have actually been in favor of the defense, as there is still ongoing treatment for the plaintiff in this case. The third is reason why the filing was late and whether that reason was within the filer's control. No address was ever provided by the insurance after the first attempt of service, and the case was continuing in good faith. And the fourth, the filer's good or bad faith. We were settling in good faith with the defense as January of 2022 property damage was settled and paid, and the settlement on the minor was done on 5/3 of 22 prior to the dismissal request.
Miss, let me ask you, you've identified yourself as Mechelle Hart on the brief. Do you want to be referred to as Miss Hart?
Yes.
Okay.
That was previous married name.
Okay, all right, I understand. Or would you, okay.
You can refer to me as either. It's just whatever's more convenient.
Well, what would you prefer?
Hart would be preferable, thank you.
Okay, so Miss Hart, so you would like us to focus, though, on the extension of the request for extension of time here?
Correct, and that we continued to settle in good faith and that they chose to continue to settle without this being an issue for over 2 years.
And I know in the case below that you had counsel that represented you in the case. Do you know what efforts were made beyond that initial attempt to serve Mr. Sanchez and the unsuccessful effort initially? Was there any other attempt to issue new process after that first time?
To be honest, I'm not sure.
Okay.
In the documentation that I was provided, I didn't find anything. That does not mean that it did not exist.
Yeah.
There could still be emails and other documentation that I did not have access to.
But as far as you're aware, it was only that first summons that was issued with the complaint.
Correct, and then the second one was not done because they waived that service at that time while they searched for his address.
And when you say waived, you're talking about the communication from the insurance company.
Correct,
Okay.
saying that they were willing to continue to negotiate settlement on different parts of the case.
Anything further? Don't want to cut you off.
No, not at this time.
All right, then you'll have time to respond to what the attorney has to say. All right,
Thank you.
we'll hear from the appellee now. All right, good afternoon.
Good afternoon, Your Honors. May it please the court, I am Eric Benton here for the appellee. I'd like to quickly address a few things that the appellant has put forth today, specifically, and some of these I will address throughout. But the first thing I'd like to address is the motion. Yes, it was a Rule 12 motion, but it was also in the alternative a Rule 3 motion for failure to serve within the 1 year of the return of the service. The case before you, the issue that we have centers around a request for extension of time as a result of excusable neglect pursuant to Rule 6.02. I would like to point out that this is under an abuse of discretion standard, and I know that this honorable court appreciates how important that is, but I do think it bears repeating today. While the underlying motion to dismiss was based, in fact, on Tennessee Rules of Civil Procedure 3, the response to the motion could be and was, in fact, construed as a motion for enlargement of time at the trial court level. And if you review the order would reflect the same. This honorable court in Manuel v. Garbs acknowledged this somewhat common scenario in which a motion to dismiss or a motion of that nature may be filed, and the response is deemed to be or could be construed as a motion for enlargement of time pursuant to Rule 6.02 due to excusable neglect. And in that same vein, the motion to dismiss itself could also be construed as the defendant's position that the failure to comply with Rule 3 was not a result of excusable neglect. Thus, there should not be a granting of extension of time pursuant to Rule 6.02. The more modern phrasing of the abuse of discretion standard from Lee Medical is whether there is a factual basis to support the ruling, whether the court properly identified legal principles and whether the decision was within a range of reason. It is the more deferential standard of review. And I'd submit to you today that the trial court's decision did consider the facts in front of it, the facts within the record, and then exhibits submitted in response to the motion to dismiss, in that the trial court properly identified the 4 factors in finding excusable neglect pursuant to a Rule 6.02 enlargement of time, and that the trial court came to a decision within a range of reason. And that decision was to dismiss the case. The events that gave rise to this case occurred on October 5th, 2019, Davidson County on Hillsborough Road. On October 1st, 2020, almost a year after the complaint was filed, summons was issued. That summons was returned as not found, and as the appellant pointed out, on the, I believe it was on the return, or on the affidavit with the return, that the process server needed a lot number. There was no way to find where the mobile home was located. Plaintiff's counsel did email the Trexas representative and explained that the defendant was not served because there was no lot number. Plaintiff's counsel did state within that email that they would like to know the lot number. What is not stated within that email is that there is or is not an attachment of the failure to serve process. Now, within counsel's affidavit that she submitted, she does say that she attached it. But based on what I have, there is, I can't look at that email and find out whether or not it was attached. Then, a day later, October 7th, 2020, a Trexas representative explains to plaintiff's counsel that this has gone to a new litigation adjuster, which is common practice, where the case is with somebody before suit is filed, and then suit is filed, and it goes to a litigation adjuster. The litigation adjuster responds to plaintiff's email regarding the address of the defendant and states, if you can get these demands to me within the next few weeks, leaving service incomplete at this time would not seem to prejudice the case in any way. I will get the address and permission to disclose the same. I would reiterate that within that email, there's a time limit of a few weeks. Specifically, it says the next few weeks. And at this time would not seem to prejudice the case in any way. Plaintiff received that return, and a year goes by, no alias summons is issued, nor was the defendant obviously ever served. Then in January 2022, the trial court dismissed the case. It was a dormant case, a docket cleaning matter for wanton lack of prosecution. In the motion to dismiss filed at the trial court level, the trial court correctly identified Williams v. Baptist as a precedential case here. In Williams v. Baptist Memorial Hospital, the Tennessee Supreme Court tells us the burden is on the plaintiff to show the failing was due to excusable neglect. The same case tells us our factors for analysis that the court must use in making this determination. Those 4 factors are the risk of prejudice to the parties opposing the late filing, the delay and its potential impact on proceedings, and the reason why the filings were late and whether they were within the filer's reasonable control. And I'm sorry, I jumped at my and the good or bad faith on the filer. As to the risk of prejudice is great, and the trial court in this matter rightly recognized that. The trial court recognized that the defendant would be forced to ultimately prepare for trial and prepare a trial strategy on an accident which at that time had happened nearly 3 years ago. Again, we are talking about an accident in October of 2019. The appellant argues that there's no prejudice whatsoever, but also proffers no evidence that there's no prejudice whatsoever. And it's her burden to proffer that evidence. Appellee has had no opportunity to engage in discovery. And in some of these cases, for instance, Webster v. Isaacs, the parties were engaged in discovery. And this motion came through, a very similar motion to dismiss. And the motion to dismiss was granted. And the Court of Appeals agreed with the motion to dismiss being granted. I would submit to you that the first factor was correctly applied and took the correct facts into consideration, and it does militate in favor of a finding for the defendant, as the trial court found. As to the second factor, the delay and its impact on proceedings, I would echo the prejudice aspect, the impact on discovery, preparing trial strategy, and as witnesses, memories fade with witnesses in evidence.
Excuse me.
Yes.
Going back to the first factor for a moment, the trial court said that one of the things that weighed against it was the defendant would have to prepare a a trial strategy with evidence and witnesses related to an event that happened almost 3 years ago due to no fault of his own. But the insurance company never got back to them with an address. Isn't there some degree of fault that should reside with the insurance company?
I do not think there's any degree of fault that should reside with the insurance company.
So they can just say, we'll get back to you on that and never do it, and it's okay.
Well, I would submit that the request should have been made pursuant to Tennessee Code annotated 56-7-1104, which would require a certified mailing of the return summons to the insurance company requesting that information. And what I would also submit is that email, if that email said, I'll get it to you, that would be one thing. But the email actually, it doesn't say that. The email says, and permission to disclose the same. And I should back up and give you the full sentence there. It is, I will ask my insured for the address and permission to disclose the same. One consideration there could be if there's any ability to get contact with the insured for the address. And I would submit that is incumbent upon the plaintiff to follow up on. And they would have the affirmative duty there. Is that, no?
That's fine.
And moving on to the second factor, again, the delay and impact on the proceedings. The case itself has impacted the trial court's docket in that it was dismissed for wanton lack of prosecution. In Williamshurst Baptist Memorial, that trial court and then the Tennessee Supreme Court highlighted what the trial court said, and the trial court said that they had been generous with extensions of time regarding expert disclosures. And in the Williams case at the trial court level, plaintiff has come then very late in the case asking for another extension of time. And I think that's important to point out because this case here can be likened to Williamshurst Baptist Memorial in that the dismissal for wanton lack of prosecution and then the setting aside of that dismissal is generous in the same manner in the way that plaintiff was given extensions of time in Williamshurst Baptist Memorial. The trial court also in our case notes that the significant delay, or substantial delay, is something that makes this factor more so weigh in favor of the defendant. Third, the reason why the filing was late and whether it was within the reasonable control of the filer. In State ex rel Sizemore versus United Physicians and recently in Webster versus Isaacs, this honorable court has noted that this may be the single most important of the four factors. The trial court noted there was nothing stopping plaintiff from reissuing summons. There's nothing stopping them at any point in time, even with these emails, even if the assumption was that everything's going honky-dory, there's still no reason that an alias summons can't be issued and just set on the file just in case. There's also a notice of appearance that was filed after the original dismissal for wanton lack of prosecution. And in that notice of appearance by my colleague Adam Porter, it's a notice of limited appearance, reserving all rights to all defenses, reserving rights to Rule 12 motions, and you take that order of dismissal and that notice of appearance together, that's a 5-alarm fire. There's something here that should be giving cause for concern. And I would further submit to you that this third factor is probably the one that relates a lot, to me at least, the most to these emails. The reason why the filing was late and whether it was within the filer's reasonable control. The email says a few weeks. When the motion to dismiss was filed, this is nearly 2 years after the fact. I believe it was 20 months or 22 months when it was filed. It is a fact applied to this factor test and it would be within reason for the trial court to decide that a few weeks is not tantamount to nearly 2 years. If this occurred potentially on day 366, where the motion to dismiss was filed on day 366, then possibly this factor militates in favor of the plaintiff. But here, since this occurs in month 20, nearly 2 years after the fact, this factor does militate in favor of the defendant. Lastly, as to the third factor, again in Sizemore versus United Physicians, the Court of Appeals notes that courts have been reluctant to find excusable neglect in circumstances where called for action was under the control of the party seeking relief, and that party failed to act reasonably to make sure the act was performed. I would submit to you that that again is what happened here, is that this was something that was within exclusive control of the plaintiff the whole time. As to the good or bad faith of the filer, the trial court found no indication of bad faith. And since my time is running out, I will also move quickly to touch one more time back on TCA 56-7-1104. That has requirements, and simply emailing and requesting an address does not follow the requirements of 56-7-1104. And I would further point out to this court that at no point in any of these email exchanges are there words of waiver, I accept service, we will tell you where you can serve the defendant. None of that ever occurred. The extension of time that was given to the plaintiff was limited. It was clearly laid out. And I would just submit to you, your honors, that the court at the trial level made findings of fact. They applied the relevant legal principles, and as such, the ruling should be affirmed. Thank you, your
All
honors.
right, thank you, Mr. Benton. Ms. Hart, you have a couple of minutes to respond.
Okay, so this case was not about enlargement. The dismissal was based on the fact that he was not served. The request for enlargement was actually filed after the judge's decision to dismiss the case, so that has no bearing on this proceeding whatsoever. It was not prejudiced, and it would not affect the witness's memory as we were settling parts of the case going through this 2-year period. The information that was used was based on doctor's documentation, and that's all written down. It's not based on someone's memory. It's based on fact that is documented. On February 4th, 2021, Judge Brothers did reinstate the case for the dismissal for nothing going forward because they did not object. The defense did not object to that as we were settling parts of the case. The return of service was filed in the court record on October 5th, 2020, after it was unservable, something that the defense had access to. And the email, she did say that within the next few weeks, and we were in constant contact with the insurance company, and then when lawyers became involved with Mr. Benton's law firm. But in that email, she also said that she would obtain his correct address and permission to disclose the same. If he refused to disclose his address or tell us where he was, we would still be in the same predicament of not being able to serve him. This has not done any detriment to the defense because if we had served him, the case would still be progressing as it had. We would have still settled my minor daughter's personal injury, which was done. We would have settled the property damage, which was done and paid out. The only thing that's not been paid out is my personal injury because I'm still being treated. In fact, have surgery in 2 weeks again. So.
All right, and I hope your surgery goes favorably. So that you all know, we will take this case under advisement like we did the others this earlier in the day, and a written decision will be prepared and filed with the clerk of the court. So it'll be important if your address or email address, mailing address or email address change, be sure to keep the clerk of the appellate court informed so that you will get the notices from the court. Thank you, and Mr. Benton. That concludes the document.